Like Dave said, my name is Dave Rowland. I'm with the Show Me Institute. And today we're going to talk a little bit about eminent domain. Eminent domain, of course, is a topic with which people in the St. Louis area are very familiar because there have been a number of projects that used eminent domain in recent years. What I want to talk about now is one of the unique elements of Missouri law as it regards eminent domain. If you'll remember, a few years back, there was a United States Supreme Court case called Kelo versus New London. And in that case, Suzette Kelo and her neighbors in the Fort Trumbull neighborhood of New London, Connecticut, were having their properties, their homes and businesses condemned by the city in an effort to replace them with luxury condominiums, high-end retail shopping, and the city tried to justify its taking of their property by saying this is going to be for economic development. This is to increase the tax receipts for the city. And so the question that the United States Supreme Court had to answer in that case is, can we consider economic development a public use under the United States Constitution? Unfortunately, the United States Supreme Court said in a 5-4 sharply divided opinion that yes, in fact, economic development could be considered a public use. This was kind of the culmination of a long string of cases for the U.S. Supreme Court. Going back to the mid-1950s, there was a case called the Berman case where the Supreme Court took the Fifth Amendment, which specifically says that if property is going to be taken from a citizen, it has to be taken for a public use. And the court said, well, we know that the words in the text say public use, but what we really think this means is a public purpose. And so, whereas previously public use had been restricted to things like courthouses or roads, things where the property that was taken was going to be owned and accessible by the public. Now, all of a sudden, it meant that you could take what belonged to one person and give it to somebody else if you thought that it would have a public benefit in the new person's hands. And public benefit was defined very broadly. So in the Kelo case, again, the question is it okay to take what belongs to one private citizen and give it over to some other private citizens simply because the city thinks it'll make more tax revenue by doing this? In Missouri, there are, well, real quick, before I get to Missouri, I'll say that the court in deciding the Kelo case essentially said it's up to the states to define the limits of eminent domain abuse. Each state has its unique constitution. Each state has limitations and definitions related to the use of eminent domain authority. And so they said basically the states can put harsher limits on the use of eminent domain if they want to, but the federal constitution doesn't require it. So property rights advocates in Missouri needed to start looking at the Missouri Constitution to see what their document says to protect property rights here. And actually, the text of the Missouri Constitution is great. Missouri has more provisions restricting eminent domain than any other state in the nation. They specifically say that you cannot take private property to give it over for a private use. That's a stricter requirement than you have in the United States Constitution. They also say that if a city or a government agency says that something is going to be for a public use, then it's up to the courts to decide whether the use is really public. One of the things that happens in other states is if the city says that something is for a public use, the courts will defer to the city's judgment. This is a terrible idea because the elected officials who are making this determination stand to benefit from calling something a public use. And so it's basically letting them be the judge in their own case. But Missouri's Constitution doesn't permit that. if a Missouri city says this is going to be for public use, the courts are required to exercise independent judgment as to whether that really is the case. So how did we get to the situation where Missouri has some of the worst abuses of eminent domain in the entire country? You know, if you've got such strong constitutional language, you would figure that, you know, the problem would resolve itself. Well, this is the story. Back into the 19th century, when Missouri was founded as a state, when the first constitutions were written, there really was a clear understanding about the limits to the use of eminent domain. I've got a quote that I'd like to read for you from an early Missouri Supreme Court case. It says, "Land can be taken for the purpose of being used by the public as a road, a canal, a bridge, or a mill, for a basin or a wharf, where the necessity exists that the public should have such use of it." So you see, they're linking very strongly to this idea of a public use rather than a public benefit. But it is not such use of it as is intended by the Constitution when land is taken for the purposes of revenue. Nor is it taken for public use, nor does the exigency exist for taking it when it is already applied exactly in the way it is proposed to use when it is taken. So they're saying you can't use eminent domain for economic development. This decision from the Missouri Supreme Court in 1851 is directly to the contrary of what the United States Supreme Court said just a couple of years ago in Kilo. So you'd think, well, you know, again, you've got a good interpretation of the Supreme Court, a good interpretation from the Supreme Court of the Missouri Constitution. What happened? Well, the problem is that the powers of government got confused. There are a handful of different powers that government has. Among them, taxation, we're all well familiar with, just having passed tax day. Eminent domain, which of course is what we're talking about today, and the police power, which is another common power of government, which is where the government uses its authority to prevent or end threats to the health, safety, or welfare of the community. What people lost sight of about the turn of the century, the turn of the 19th into the 20th century, was this distinction between taking property because it's useful and trying to prevent harms. If you'll remember, about the time of the Great Depression, the cities were growing because you had a strong influx of people from agricultural areas looking for work, and you had the rise of what were considered slum and blighted areas. These are just pockets of town, parts of town, where a whole bunch of poor people were living. And frequently, the conditions there would be pretty bad. You'd have large numbers of people living in very small dwelling places. You'd have crime happening in these areas. The landlords wouldn't be receiving enough money in rent to keep up the properties, and so they'd fall into disrepair, and it was very dangerous. And so public officials, this is the era of progressivism that we're talking about, public officials said, well, we don't want people living in these kinds of conditions. So what we're going to do is we're going to take away these properties from their owners, and we're going to build these brand spanking new public housing developments in their place. Well, there was a problem.